Hello, everybody. Hello. Hello, everybody. Am I clearly visible and audible? Please tell me. Yes, people. Yes. Perfect. We are clearly visible and audible, right? Perfect. 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 All right, everybody. Today we are starting with a very important session in NLSAT B. All right. It's a very important session, you all. All right. All right. So before we begin, let us first understand what this examination is all about. All right, basically, the NLSAT is your National Law School Admission Test, right? It is conducted for the 3-year LLB program. So dear. Yes, bache, so NLSAT is the program for 3-year LLB in NLSIU Bangalore, right? The OG NLSIU Bangalore, right? So this exam is for that. Okay, we perfect, perfect. Yes, yes, yes. It offers 3-year LLB at NLSIU Bangalore. So before we get into part B particularly, let us first understand what this exam is overall. Okay. First of all, bache, the target program is for an 3-year LLB. After that, the exam generally prefers aptitude over rote learning. Now, what do we mean by that? But say this is one exam that tests your legal acumen. Okay, it is not testing your legal knowledge. It only tests your legal acumen, your aptitude for law. Okay, yes, Aftab, it is very much possible if you start now in the span of 3.5 to 4 months, you can do well in this examination. Why am I saying this? See, bache, this is not your typical sarkari examination where you have a fixed syllabus that you have to learn, you have to cram it, memorize it. Not at all. This is just an examination that tests your legal acumen. It tests your aptitude. All right, bache. So yes, it is very much possible. And this session is actually a wake-up call for everybody who are aspiring to write this paper, right? If you are an NLSAT aspirant, I think December end is the perfect time for you to actually wake up and get serious about your preparation. All right, bache, today I will be sharing my personal strategy that I used, right? For a student in law faculty, Delhi University, I believe. Perfect. There are a lot of students from DU, CLC, LC1, LC2 who generally write this paper and they clear it and then they change the same. It is very common, bache, right? So what we'll do is we'll stop chatting for a while now and we'll focus on what is being said here. All right, very good, bache. Now, bache, let's talk about the structure of paper a little bit. This exam has two sections, Part A, Part B. All right, we have two sections in this paper, Part A and Part B. Now, Part A is an objective paper, MCQ based paper, 4 options, 1 correct answer. That is Part A. All right, everybody, perfect. Then I have Part B, which is subjective, descriptive paper, where I write my answer. Part A is objective, it is an MCQ based paper. Now, in Part A, my dear, there are 75 questions. In your Part A, there are 75 questions, topics like English, critical reasoning, GK, and current affairs. GK and current affairs. Now, you must note that only after you clear Part A, then your Part B answers will be checked, right? So, if you want your descriptive answers, your Part B answers to be checked, you have to clear the cutoff of Part A first. Now, what is the cutoff? If you are from general category, the safe score is usually 50 to 55, right? Now this has been till now. Now awareness is increasing, competition is increasing. I would say this can also go above 55. So for this year, for 2026, 55 plus would be the safe score for part A. You should remember, if you are not clearing part A, your part B answer copies will not be checked. They will go straight into the dustbin of NLSIU Bangalore, right? So we don't want that happening. We have to prepare well for this particular section. Now, more about part A, we will discuss in upcoming lectures, right? This particular lecture is for part B, right? No, dear, NLSAT is only for graduates, people who have completed their graduation. All right, perfect, perfect. So part A, you have to clarify. It is clarifying in nature, only then your part B will be checked. Part A we will discuss later on. This lecture is specifically for part B. All right, all right. Now, bache, in your part B, you have two types of questions. One is the legal reasoning question. You have 6 questions for 10 marks each. What did I say? Here you have 6 questions for 10 marks each, 60 marks. All right. Then you have a 15 marker essay. Right, bache? 10 marker legal reasoning question, 6, and 1 essay for 15 marks. Right. This essay we will discuss in subsequent lectures. In this particular lecture, we are only discussing the legal essays. Okay, the legal reasoning questions that are there. Perfect, perfect, perfect. Now, what are these questions? Let us understand. What are these 60 mark questions in the legal reasoning? First of all, bache, the weightage is 60 marks, 6 questions are there. Format is legal essay or problem-based scenario. What they do is, bache, they always give you some fictional essays. Always remember, I'm highlighting this point. All the questions you have given essays that are fictional in nature. They are inspired by current events, the current socio-legal events. For example, there was this movie, if you watch, there was this movie called Huck, right, which was based on a famous case law. They can give you a scenario like that, right? There was this war between Israel and Palestine. They can give you a fictional scenario like that. Scenarios are always fictional. All right, remember that. Now, why is it? Why are they giving fictional scenarios? Why they can also give real life scenario, right? Why do they give fictional scenarios? So they can minimize subjectivity. So then they can minimize the personal bias, because when the professors check your examination, what if they favor one side over the other? So in order to minimize that personal bias, they make these essays very fictional, right? All the essays are fictional. Perfect. Now there are certain steps we need to follow while we answer these questions. The very first one is, bache, always unlearn the law. Whatever you studied in your IPC, CRPC, BNS, Evidence Act, forget all of them. None of that applies here. Whatever laws, whatever legal principles you have studied, please forget that. Now, a lot of teachers tell you that this is unnecessary. This is not only unnecessary, you can also deduct your mark if you use these concepts. Why? We only stick to the passage. Whatever facts, whatever laws are given in the passage, only that we consider. Anything outside of the passage, we are not going to consider. Otherwise, we will lose marks, right? Our marks will be deducted if you try to use some BNS, CRPC, IPC. Forget all of that. Unlearn all of that. In these essays, we will use only the facts, the principles given in the passage. Okay, everybody? Perfect. Now, there is a structure, so to say, that we follow. There are certain steps that we follow while we do these questions. We'll quickly understand that. Then I'll take you to a question. Okay, everybody? First, active reading. But say whenever you see a question, read the facts very carefully. Always read the facts. You have to separate the material fact from contextual noise or background. You have to identify which facts are actually the material fact, important fact, and which facts are just supplementary or extra details, which is just the background. After that, you have to identify the missing link or the loophole, right? But you have to think like a lawyer, look for any loopholes that are there in the passage, and then we follow this IRAC technique. We'll learn more about that later. First, let's look at a question. I'll again tell you little steps that we follow. First, read the passage. Okay, read the passage and paraphrase it as per your position. Okay, I rewrite the fact of my case in a way that they favor my position. Then I pick a side. Always pick a side based on the side where you can generate maximum arguments. Never pick a side based on emotions. Ki, acha, I thought this is right, so I'll pick this side. No, never pick a side based on emotions. Always pick your side based on logic. How many arguments you can form? Yes, bache, this is NLSAT. Is this screen visible to all of you? Just tell me very quickly. Can you read what's written here? Or is it too blurry? Yes, everybody? Are we able to read it? Tell me very quickly. I'll read it for you. Can we read this? No, you can't. No problem. What I'll do is, yeah, there is some problem with the font. What I'll do is, I will read this question for you. No problem. No problem, everybody. No problem. I will read this question. Okay, I will read this question for you and I'll teach you how we do these questions. It is visible, but not zoom. You want me to zoom? I'll zoom it a little. I'm also reading it for you. No worries, people. I'm reading it for you. The fact of the case is the Republic of Fresco and the Democratic Union Territories of Western Fetherland entered into a treaty. Okay. Yes, bache. Yes, bache. They entered, these are two parties, they entered into a treaty which provided the legal framework for investors in each of the countries to make investment. Okay, perfect. Now that the treaty prohibited expropriation. Okay, they prohibited, but please listen carefully. They prohibited expropriation, which is defined as taking off an investment by the state or any other action of that amount taking investment or substantiate deprivation of the enjoyment of investment when not backed by public purpose. What are they saying? What is the treaty saying? Treaty is saying if any government is taking the investment or they are prohibiting the other person from enjoying on the investment unless it is due to public purpose, that is prohibited. You cannot do it. This is just the law that they have given. If anybody violate this, they will be brought to WCDS, which is World Court for Dispute Resolution. Be clear till here? Have you understood the law, bache? The law is very simple, very basic. There is a law that says one country invests in another country. You cannot take the investment. You cannot prohibit the party from enjoying the investment. If you do that, you will be brought to the WCDS, the World Code of Dispute Resolution. Are we clear till here? Please tell me yes or no. Have we understood the law very nicely? Yes, everybody, have we understood the law? Tell me yes or no. Have we understood the law, people? Yes. Yes, everybody, have we understood the law? What I'll do is, after the class, I will also attach this PDF in the description box so you can read it. Anybody who is watching the lecture on YouTube, recorded lecture, you can go through this PDF via the description box. I'll add it there. Perfect, perfect, perfect. We have understood the law. Now we'll move to the facts of the case. Fact. Okay, what are the facts? There is this burger company called Woohoo Burgers, right? They are operating in Fresco. They decided to open branches in Featherhead, the protection. treaty. Yes, everybody. Now the decision was profitable. They were making lots of money, right? It was a profitable decision. In July 2023, Netherlands published a research. The university published a research which indicated that certain fast food burgers had drastic impact on the health of the people. They also said that the attractive packaging was due to the packaging that they were buying these products a lot. This country decided that we are coming up with a new law. We are creating a new law that all these companies, they have to put a warning. Their packaging have to convert their packaging to standard for new. What they're saying is should be your font, all your packaging be black and white. Okay? All your packaging black and white. Examiner asks you, can this company, Woohoo Burger, take them to the World Court of Dispute Resolution? Tell me, can they do it? Should the court entertain their argument? But have you understood the fact of the case? Tell me, everybody, very quickly. My voice is breaking. Is it better now? Yes, bache, is my voice better now? Are you okay? Vikyat has given me the answer already. Okay, let me hold it like this. Yes, people, is my voice better now? Vikyat says no, they cannot. Perfect. Okay, is it better now, bache? I think it will not break now that I'm holding it like this. Yes, bache, tell me your answers. What do you think? Do you think this Woohoo Burgers? No, ma'am. They're okay. No, a lot of you are saying no, ma'am. No, their arguments will not be entertained. Right? Tell me the answer, bache. Do you think this Woohoo Burger? Bhumi says, I'm not understanding. You're not understanding what, Bhumi? Shall I repeat the facts of the case for you? What are you not understanding, dear? Shall I repeat the facts of the case? Very easy, bache. There is one law that one country cannot take the investment of the other country. They cannot prevent them from enjoying the investment. All right? They cannot prevent. The exact wording is that they cannot uh, do substantiative deprivation of enjoyment of investment. They cannot do that. Okay? It is prohibited. It is banned. Now, in the facts, we are saying this one company said all the companies, all the burger companies, they have to put a warning label and they have to change the font to born new and black and white. All the packaging should be black and white. So, do you think these people they should be taken to court because they have violated the treaty? Tell me, should we take them to court? Should we not? Give me a yes or no, everybody. Lot of you have said no. Vikyat says no, right? Aftab says no. Bhumi also says no. Chaliye, chaliye, chaliye. Okay, chaliye, chaliye. Let's understand that. See, bache, the speciality of these types of questions is that there is no one right or wrong answer here. Okay, if you say yes, their arguments will succeed, you are right. If I say no, the arguments will not succeed, I am also right. The only thing that is needed here is that you should be able to substantiate your argument. You should be able to prove your side. All right, how do we do it? We'll understand very quickly. I'll show you just a second here. Let me erase all of it. Yes. We'll discuss each side one by one, okay? One by one, we'll discuss. What is the step by step process of doing it? What is the step by step process? Step one, always paraphrase the question. What does it mean to paraphrase the question? You have to tell your examiner, you have to show your examiner that you have understood the facts of the case. How are you going to do that? How are you going to do that? Whatever side I have picked, let's say you all are saying no, they should not succeed. i'll I'll take your side now, for now. So I'll say whatever the facts are, I will twist the facts, I will present the fact in a way that they favor my position. Why? I will highlight the word public purpose. Why? Because in the case, the mandatory law that came in, it was due to the health risks, right? So the word public purpose should be highlighted, right, bache? When I write my first paragraph, I will highlight this word public purpose. Very first paragraph, paraphrase the question. Whatever facts are given in the question, write it as it is, but make slight differences. Write it in a way that it favors my position. So when I rewrite the fact of this case, I will highlight that yes, first and foremost, this law was brought in view of public purpose. It was backed by public purpose. So even if it is, let's say, preventing them from enjoying their investment, it cannot be questioned. Why? Because it is backed by public purpose. Core argument number one. Core argument number two can be, in this case, they are not preventing anybody from enjoying the investment. They are simply making a law. They are not taking the investment. Right? What does the act says? You will rewrite the act in the perspective of your position. Are we clear till here, people? Just tell me yes or no. What we do is, first we rewrite the facts of the case and we prove why our position is a better position. Okay. For example, if you want to say no, they will not succeed, first you will write the case that as per the facts of the case, it is clearly stated that the law was brought in view of public purpose, and hence the woohoo burgers cannot succeed in making their arguments before the court, right? I will, whenever I make a point, I will always use the terminologies given in the passage. It gives you extra points. Okay, everybody, when you use the terminology of the passage, it gives you extra points. Second argument, I will write just 2 to 3 arguments and then I will conclude my answer. Second argument could be, the law clearly says that the treaty is said to be violated only if the party is preventing the other party from, let's say, enjoying the investment. But that is not happening in this case. That would be your second argument. Yes, everybody, tell me in the chat, are we understanding? Is this understood to all of you? Yes, everybody. Very good. Very good. Very good. Yes, yes, yes. Lovely. And in the end, I simply write a conclusion. In the end, I write a conclusion. Now, if you follow this structure, first you have stated the facts from your perspective. Then you write 2 core arguments. What are we doing, bache? First, we are simply paraphrasing whatever is given in the question. We are repeating it from our perspective. Then you give 2 core arguments. And then you write a conclusion. You will get 6 on 10 very easily, right? You can get 6 on 10. 6 on 10 you have gotten till here. But ma'am, I want to get 7 or 8. How do I take my answer from 6 to 8? Very easy. Just add a rebuttal. What is a rebuttal? Rebuttal is you anticipate. You try to guess what argument can the other side make. For example, in this case, I'm saying that okay, this was backed by public purpose and we have not taken anybody's investment. So they cannot succeed. What argument can opposing side make? Tell me in the chat very quickly. What argument can the opposing side who are favoring the chips company, the burger company, what arguments can they make? Tell me in the chat very quickly. What argument can they people make to say that yes, their arguments will be entertained by the court? Tell me quickly, people, what arguments can the opposing side make? Tell me quickly. Yes, everybody. What arguments can the opposing side make? Tell me. No answer. No answer. Chaliye. Now, see, I'll tell you. The opposing side can say that although directly they're not taking any investment, but they are prohibiting us from enjoying the returns or our investment because this rule that they have brought in, this will reduce the profit. People will stop buying the burgers, right? It will impact their profit. They will go into losses. Very good, Vikyat. The state's action would interfere in working of the company, right? So what I'll do is the only difference between a 6 marker essay and an 8 marker answer is that the 6 mark one will only say why I am right. This one will also say why the opposing side is wrong. You can you can write a good rebuttal for this argument. You can say, so the opposing side might argue that the state's action would interfere in the working of the company. Such arguments have no merit. Such arguments have no merit because the entire law has been enforced due to a public purpose, from a public purpose. And the act very categorically says that if the action is backed by public purpose, that will be an exception. So we have that exception, which is why this will not amount to, let's say, expropriation. Yes, everybody. What I have done is I have taken one argument from the opposing side and I have debunked that argument in my answer. Yes, if you do that, your answer would very easily go from a 6 to an 8. Yes, people, have we understood? Tell me very quickly how we do this. Introduction. Write the facts of the case from your perspective. Whatever facts are favoring you, highlight those. Whatever facts are going against you, just minimize those facts. Just tell them, oh, these are secondary, these are not important. Then you write the core arguments. Then I debunk the arguments of my opponent and then I write a conclusion. This is the perfect recipe for an 8 marker essay. Have we understood it till here? Tell me yes or no and we'll move forward. Okay, people, if we have understood till here, I will take you to a model essay. Tell me quickly, bache, have we understood this blueprint? We'll understand that later, bache. Yes, you're right. I'll tell you in detail. First, I'll show you the model answer. Have you understood till here? If yes, I'll take you to the model answer. Yes, people, are we clear till here? Perfect. Perfect. Tell me, can you read this? Is this legible or not? Tell me, everybody. Is this legible? Yes. Is this legible, bache? Can you read this? Two to three argument are sufficient, Vikhyat, bache. Or two argument and one rebuttal, whatever way you like. But he's saying, no, ma'am, the answer. Just a second. Also, please increase the resolution on your YouTube. If you're watching it at, don't you know, resolution, just increase or enhance the resolution. You would be able to read it. Yes, people, tell me. Too blurry. Was it better earlier or is it fine now? Okay, just increase the resolution of your YouTube, no? Better now? No problem. Even if you cannot read it, relax. I'm going to read it. Too bright. Okay, no problem. No problem. What I'll do is I will read this. From next time onwards, what I'll do is I'll convert this on a format. But it's this. This is back from when I was preparing for this paper. I used to write people. Quickly we'll see that. No problem. If it's blurry, if you're not able to read it, just follow me. I'm going to read it for you. Okay, people, I'm going to read it for you. I'm just teaching you the mindset. How do you approach these questions? Yes, people, I'm simply teaching you the mindset. How do you approach these questions? Okay, perfect. Don't worry, don't worry. No need to worry, bache. I started. See, we have seen the facts of this case. What were the facts? That there is one law which says expropriation is banned. You cannot take anybody's investment, but it's allowed if it's for a public purpose, right? Then the facts of the case were there. What I did here was, bache, identified what facts can work in my favor. What facts can work in my favor? Now, I like to play the devil's advocate a little bit. Majority of people would say, "Ha, ma'am, public purpose se kiya hai. How will you succeed in making the court entertain your argument? You cannot do that." Yes, that is right. That is the easiest way out. उसके लिए बहुत ज़्यादा arguments you can get. But as I said, I like to play the devil's advocate. So I preferred the side which says, yes, they will succeed. Okay, that yes, they will succeed when they go to the court of resolution. Now, how did I frame my answer? We'll quickly look at that and then we'll understand. Let's read here. The fact of the case very unequivocally suggests that, now these are some transition words, undoubtedly, categorically. These are some words. I'll give you the list. You can use it in your answers. Yes, people, these are some words you can use in your answers. I'll give you the list, okay? So yeah, the fact of the case suggests that Woohoo Burger's argument should be accepted by the court. Okay. In the first line, always give your stance, your judgment, or the side that you're taking. Why? We are not here to play hide and seek with the examiner, right? We are not here to play some sort of hide and seek with the examiner. Very first line, clarify your stance. This is the side I am taking. All right, people. So in the first line, I have clarified my stance. This is the side that I'm taking. After that, I'm explaining why. Now comes my core argument. As the term expropriation, by definition, means taking of an investment by the state or any other action of the state that amount to the taking of investment by the state or substantial deprivation of enjoyment of the investment. Now, this is just the fact of the case. I told you now, you have to write, you have to explain the examiner that I have understood the case. I did nothing. I took this definition and I said, see, examiner, by definition, expropriation means this. The word or suggests that fulfillment of any one of the three situations amount to expropriation. What did I say here? They have given three, let's say, situation. One, you take the investment, you do any action that take the investment, or you prohibit the person from enjoying the investment. I have said in the first line that the definition has the word or. Or means what? All three conditions are not necessary to be satisfied. Even if one condition is satisfying, appropriation is done. Further, I'm stating the fact of the case very categorically state that the government of Netherlands has mandated replacement of Woohoo Burger's distinctive packaging. What is the core argument here? What is the core argument here, bache? I'm saying that the government, the state, when it bought the new law, it has replaced the distinctive packaging of Woohoo burgers with a standard black and white packaging. It was given in the question, right? The question said you have to, the fact of the case says all the packaging should be black and white. Yes. So what they're doing is जो उनका distinctive packaging था, that is being replaced with the black and white font, substantially depriving the investor of enjoying its investment. Although no physical taking occurred. What are we saying? We are saying yes, you have not physically taken the investment, but what you're doing is you are destroying the economic utility of the product. Yes, bache, my core argument is that yes, you are not physically taking the investment, but your decision has destroyed the economic utility of the product. So you are indirectly preventing them, you are prohibiting them to enjoy the returns on their investment. Okay, perfect. Then again, using the facts of the case, I say the facts categorically state that in the study, even in the study published by the state, it was found that packaging is a core component, right? It is the core component that brings commercial value to the product. So when you are eliminating this feature, you are effectively destroying their possibility of earning returns. You are killing the economic utility, which is amounting to indirect expropriation. Yes, this is amounting to indirect expropriation. What I have done here, the fact of the case are same. I've just tweaked it in my favor. Yes, everybody. After that, I have taken a counter argument from their side. Counter argument. Right? What I've said is, I said, okay, now the other side might say that this was done uh, in view of public purpose. However, only the mandating health warning can be justified, but mandating a black and white packaging replacing their core competence is, it is not just unnecessary, it also gives an evidence for the intention of the state to prohibit Woohoo burgers from enjoying returns on their investment. What I'm saying is, on and on, I'm simply saying that you are not physically taking the investment, but you have deliberately made this law. Now, a counter argument might come कि अरे ये तो public good में, it is because of some public purpose. I will debunk that argument. I will say no. If you wanted it to be due to a public purpose, okay, you put the health warning, that is fine. But why are you killing my core competency of packaging? This shows that it gives an evidence that yes, you had an intention of killing my profits. You want to prevent me from enjoying the profits on my investment. And hence, I give a conclusion that this has amounted to expropriation. Yes. Now, what I want to teach you from this one example is that irrespective of what side you take, bache, irrespective of whatever side you take, you can always form your arguments. In what sense? First paraphrase the question, write the facts. Whatever facts work in your favor, highlight it. Whatever fact work against you, just diminish it. Say, oh, this is just extra information. This is not the core fact. Then you write your argument. You write one counter argument and you debunk that argument. Then you give your conclusion. This is precisely how you write an easily 8 on. Yes, people. Whatever we have started here, I will just give you a nice structure for the same now. Look, this is the IRAC formula, so to say. Let's understand it. The first is understanding the issue. I stands for issue, bache. State the core legal or ethical question clearly. Now, do not copy paste कि question में जो लिखा है I'll repeat the same. No, do it from your side. Okay, just tweak the facts. Whatever fact is in your favor, again highlight it. Whatever fact goes against you, diminish or minimize it. Yes, bache, state the issue, whether the party A's silence constitute a brief, so and so forth. In the first para, again, don't play hide and seek with the examiner. In the first para, state your position very clearly. Then comes the rule or principle. Go to the logic that is given in the prompt. The logic will always be there in the question. Okay, bache, the logic will always be there in the question. So first you mention the issue, what issue is there, then you mention the logic, the principle that is given in the question. You take from the prompt. If no rule is given, then you can say the first principle of fairness, reasonableness, public interest, etc. Then application. Once you have understood, very good, Aftab. You have very clearly understood. Yes, Aftab has given me a one liner summary of today's session that, in a nutshell, you have to behave like a lawyer, take one side and defend it. Perfect, perfect. Now, you have to be balanced in this case. But you see, the example that I showed you, what I did there was, in that example, I simply said, I took a balanced point of view. I said, okay, you give health warnings, warning labels are fine, but you cannot mandate a black and white packaging, right? So it is very important, whenever you're picking a side, always you should know when to pick an extreme side, when to balance your view, right? You have to do that. Perfect, perfect. Then of course you provide a conclusion. Yes, everybody, I hope we have understood. I'll give you a quick structure now. How do I write this? First paragraph, you write the facts. Okay, you write the facts from your perspective. Second paragraph, highlight your favoring fact, downplay the fact that goes against you. Second and third paragraph, core argument. Your core argument should be there. Paragraph 4 is counter argument. Write a counter argument and give a nice rebuttal for it. Debunk it. First, I write opposing argument, then I debunk that argument. After that, write your rebuttal. Finally, conclusion as to why my side of the world is best, why what we are saying makes complete sense. Always add this conclusion in the end, which will act like a final verdict. Are we understood? Yes, everybody. Is there any doubt? Tell me. This is exact structure that we will be following. You can write it down somewhere, right? You can write it down and practice by using this structure. Right? This will give a nice uniformity and ease of checking. Yes, everybody. And then of course we have some basic tips like write in clean legible handwriting. I'm not asking you to write in cursive writing. No, don't do that. But your handwriting should be nice. It should be neat and legible. Yes, everybody. Perfect. Perfect. If we have any doubts pertaining to this particular section, you can ask me now. Yes, people, do we have a doubt now? The same thing, dear. Rebuttal is precisely when you are debunking the other side's argument, right? Yes, you can usually you can debunk as many arguments as you want. I would say 1 to 2 is more than sufficient. Can we get the PDF of this? Yes, Aftab Bache. Yes, yes. I will give you PDF of this. Okay, I will share the PDF with you all after the session. Okay, I'll upload it. Yes. Do we have any more doubt or queries here? If you have any further questions, you can ask me, or else we will end the session now. Yes, everybody. Yes. All right then. Perfect, perfect, perfect. All right, everybody. All right, all right. This is just the first session, okay? So we'll keep it very tight, okay? You don't have to worry a lot. You have got the structure. Keep practicing, okay? Just keep practicing, and you should always get a mentor who can check your answers and see where you're lacking. Very good. All right, everybody. Since we don't have any further doubt, you're most welcome, everybody. All right. Just keep practicing. Okay. We will come up with another session very soon. Thank you so much, Aftab. I'm really glad you all like this session. See you all then. Bye bye.